Welcome to the Red Light Exposé podcast.
We are an international grassroots survivor-led circle.
Our goal is to counter the growing acceptance of sex work ideology.
We aim to raise awareness of the harms of commercializing sex, meaning prostitution, porn, stripping, and BDSM.
Through honest, in-depth conversations, we elevate voices often ignored and silenced.
Together, we're challenging stereotypes and dismantling myths.
We envision a healthier, safer society, especially for girls and women.
We appreciate your company on this journey. Welcome back to the Red Light Exposé podcast. My name is Elly Arrow. I'm coming to you from Germany. I'm an advocate against commercial sexual exploitation. And as longtime listeners know, on this show, we care to look beyond the narrow view on trafficking and sexual exploitation and look at where types of power abuses and sexual exploitation logic shows up throughout society. We've talked about how it shows up in intimate partnerships, and today we'll talk about how it shows up in regular workplaces, in whole industries where entry, mostly to women, but also some men, is barred by more powerful individuals who leverage that power of controlling that access to access people, harass them, and commit really serious sexual violence against them. We'll also be touching on the idea of the gold digger, not just, again, in an intimate relationship, but in a professional setting, women wanting to get ahead by giving out sexual favors and how that narrative harms victims of these crimes. And so to get into all of that, mostly in the US context today, we have a special guest. With us today is Derek Smith, or do you prefer Derek T. Smith?
Derek Smith is fine. And Elly, thank you so much for having me on your show. These are very important topics. These are topics that everyone needs to understand, to recognize, to know their rights. And I really look forward to talking with you about them today.
As the managing partner at Derek Smith Law Firm, which is a firm specialized in cases of workplace sexual harassment, Derek, can you briefly introduce yourself to our audience in terms of your qualifications and also what launched your passion to represent victims of exactly these types of crimes?
Sure. So I've been doing this for over 30 years, and I'm not the type of person to ever have a boss. So I opened up my law practice day one. As soon as I got my law license, I opened up my practice. And over the years, we've grown and grown and grown. And I remember when it all started, when in my first office, it was an office suite, one of the other lawyers on the floor said, "Hey, Derek, I got this case. Would you be interested in it?" And he told me about it. And it was a very nice executive assistant in a big music company. And her boss was hitting on her, staring at her breasts constantly when they would talk. And one day he gave her a fortune cookie. When she opened up the fortune cookie, he's staring at her and he says, "Go ahead, open it. And she opens it and it says, "Happiness is when you suck a prick." And that was like the last straw. So she came to this lawyer on my floor. He didn't do this type of work. And he asked me about it. And I said, "Oh my God, that's terrible." I really felt bad for her. And I immediately went to the Strand bookstore, which has been around forever in Union Square in New York City. And I bought up every book I could find on sexual harassment and the law. And I ended up memorizing, studying it like I was studying for the bar exam. And I ended up taking her case and doing quite well with her and helping her. And I realized this is something that's really fulfilling. I very much enjoy this. And I also realized something very interesting, that most lawyers don't really know the law that well because they know from having a boss teaching them and telling them what the law is or learning as they go, but they don't really memorize the law and understand the law itself as if you're studying for the bar exam or something. So fortunately, I had that knowledge and I used it and it served me well. And now we're able to help people in New York, Pennsylvania, Florida, all over California, and Washington, D.C. And we have offices in, LA, Philadelphia. And so if anybody has ever suffered any type of sexual harassment, sexual discrimination case, by all means, there are lots of people with good experience who can help you. And I can tell you this, as a lawyer helping those people, it's very fulfilling. And in the 30 years that I've been doing this, I wouldn't change anything.
So in those 30 years, you must have represented a lot of different clients. And I'd like to know, can you outline for us sort of a typical profile who comes to you? Is this happen in any industry really, or are the more exclusive or high earning ones represented more? Or what about working class, more entry level jobs? Or what are you seeing? What are some exemplary cases, but even also some extremes that people might not expect where this sort of abuse and exploitation occurs?
Unfortunately, it's everything. Every industry, every single industry has some forms of sexual harassment. No one is immune. This is something that people have to face and have to work with. And a brief comment, law and doctors are some of the professions where we're actually trying to eliminate our positions, specifically discrimination, sexual harassment. We would love it if we didn't have to do this. And we have damages such as punitive damages and high verdicts. And you would think that people would get the message to stop doing this, but they don't. And it happens in restaurant industries, pharmaceuticals, construction, media, healthcare, even law firms, finance companies, you name it. As long as there are people, deviant people, with sexual urges or wanting to exert their power in some sort of sick way, there's going to be sexual harassment, sexual assault, and it's something that we need to deal with. We need to punish these people, and we need to compensate the victims. So I wish I could say, oh, stay away from this particular industry, but it's everything.
And just to be clear, the terms of the gravity of the crime, so verbal harassment, I think is already quite serious, but I'm sure as you've seen, verbal harassment can spiral into unwanted touching, can spiral into pressure to go on a quote unquote date. And are you dealing with physical assault and rape cases as well on top of these sorts of crimes?
Everything. So judges, mediators, defense attorneys, they all value cases differently. And it's kind of sick to think about what is the value of a case? How do you value? Because you really can't. You can't take back somebody's dignity from being sexually harassed, sexually assaulted. But it does span the whole gamut. And they take a look. Okay, was the person only commented to with comments of a sexual nature? All right. Did there then involve any sort of touching? What was the level of touching? Was it kissing? Was it massaging of the neck and shoulders? Was it a touch on the groin? Or did it go even further, such as forced sex, rape? And then simultaneously, the courts and judges and lawyers, they all look at how did it affect the person? Did it cause them to lose sleep? Did it cause them to take anti-anxiety medicine, antidepressants, see a psychologist for a long time, go to any trauma centers? Did they go to the emergency room? God forbid, did they get suicidal? God forbid, even worse, did they even succeed in committing suicide? And we've seen cases like that as well. So yes, it's sexual harassment. The true definition is unwanted comments or conduct of a sexual nature that have the purpose or effect of unreasonably interfering with the work environment in a work scenario. Outside of the work scenario, it's obviously any comments or conduct of a sexual nature that have seriously offended someone or caused any sort of damage.
As you said, the law in this area is complex in nature, or it's not taught enough, or maybe both of these things. Again, I'm German, I'm even outside the US, and we've got our own sexual harassment law. And I'm sort of seeing the legal fight over all types of crimes against women constantly playing catch up with reality. And my understanding of these types of crimes in the US is there had to be lots of advocacy movements, cases setting a legal premise in order for the severity of these crimes to be fully recognized, for at least somewhat workable laws to be in place for victims to use. Can you give us a brief overview of the history of the relevant law in this area and the different people who advocated for it?
Absolutely. And you take a look back at the lack of rights that women used to have, that they couldn't own property it was not illegal to rape your own wife up until a couple of decades ago.
In Germany, it was 1997. That's in my lifetime.
Which is like mind-blowing. I can't even fathom that. It's a stain on society. There's something wrong with us if it took that long. But thank God, at least now, we've got a change in that. But, back in the 60s, we had a big law come about in the United States called the Title VII of the Civil Rights Act of 1964. And this act, when it was being debated by Congress, it was originally prohibiting in employment discrimination based on race, religion, ethnicity. And someone suggested gender and said, oh yeah, why don't you just make it illegal to have sex, as like a sarcastic criticism. And somebody did say, yes, let's put it in there. And the definition of gender and sex back then, and somewhat today, but mostly back then, sex and gender were equivalent. So in 1964, the United States enacted this law which says that you can't discriminate against somebody based on gender or sex. And all that meant at first was, okay, should I have a man in this job or a woman in this job? I'm going to go with a man because I think a man would do better. So that it would be actual discrimination based on the person's gender. But what about the concept of sexual harassment? The concept of a woman who at work is being abused, harassed because she's a woman, and men hitting on her. I mean, if you take a look at like a James Bond movie from the 60s, or if you watched any of Mad Men, it was a commonplace for secretaries to have sex with their boss. I've even spoken to friends of my parents, and they've told me about this. And slapping on the ass, it was rampant in something called quid pro quo sexual harassment, which basically means this for that in Latin, that if you want to have this job, you better have sex with me. That just went on all over the place.
My mom trained as a nurse in Germany in a hospital in the 80s, and the doctors would comment on and touch both the nurses and sometimes the female patients even. So that was happening in the 80s in Germany without consequence.
Again, insane on two levels. I can't believe you just told me that. It not only was it the nurses who were working there, okay, who were vulnerable enough because of their lack of rights, but also the patients who are now in need and in bed and laid up with their injuries or illness, and the doctors would sexually assault them.
That's the whole thing. The history of gynecology is nightmarish, unfortunately, because this was in a gynecological ward. But if I say focused on the nurses, they were being sexually harassed, pretty severely, even touched by their bosses.
This goes back to what you were asking me before. What industries, all industries, whether you're an employee, a customer, patient, everyone is vulnerable. And when it happens, they have rights and they can come forward. And very often they can come forward as a John Doe or Jane Doe anonymously. But I do want to get back to you were asking me about the history of sexual harassment. And this wonderful author, Catherine McKinnon, published a book in 1979 called Sexual Harassment of Working Women. And she made the deceptively simple argument that when a man with workplace power demands sex from a woman who needs a job, that's not a personal thing. It's not between the guy and the girl. This is structural sex discrimination. It's use of economic coercion, that quid pro quo, that targets women as a class. So that was the argument. And about 7 years later, the Supreme Court heard a case which changed everything. And that was called Meritor Savings Bank versus Vinson. And I quote this case all the time. Today, we talk about this. And it involved, like, let's say a bank manager who was forcing one of his employees to come into the office and say, hey, let's have sex. And she didn't want to do it. She told him she didn't want to do it. But she ended up having sex with her boss in his office dozens of times, if not more, again and again and again. And the issue, this was groundbreaking, was that consensual? And because it was consensual, can she still sue for sexual harassment even though she didn't want to do it? And the Supreme Court of the United States said, one, sexual discrimination doesn't just have to be you don't get hired because you're a man or a woman. It could also be act of sexual aggression like this. But most importantly, as it pertains to what I use it for today, it's irrelevant. If the woman consented to have sex with her boss, what's relevant is, was it unwanted? And that unwanted means subjectively, she didn't want to do it. And that also means objectively, she let it be known to the guy she didn't want to do it, whether it be verbally, no, rolling of her eyes even, maybe a comment, I'm married. It could be anything. And so this case was groundbreaking, and it gave women so many more rights that even if they agree to have sex with their boss, they could still do something about it if it was unwanted.
That actually gets to the core of our mission on the podcast, this flimsy idea of consent that proliferates to this day in society. If a man asks a woman 15 times and the 15th time he's ground her down to the point that she says yes, that yes is not particularly meaningful. There is no mutual desire. She's not comfortable. She's not attracted. She's acquiescing and enduring. And that's something that we constantly get back to on the podcast, that cannot be our sexual culture. And I know that the law is imperfect and there are gray situations in human interactions. But if we demand that for our intimate relationships, we demand that for our workplaces, and we should also, this is our mission, right? That you can also not commercialize sexuality in the very literal sense in prostitution or other parts of the exploitation industry, because you're not getting authentic mutual desire. You are, by poverty or drugs or pressure or bullying or overt trafficking, pushing somebody into that sex act with you. And so getting that superficial consent is not particularly meaningful, cannot be the guiding light in society for sexual interactions about what's moral, what's not, what's legal, what's not. Gaining that recognition in other areas is important for all the other ones. So still sticking a little bit with U.S. history, all around this, I would like to get your thoughts on the Clarence Thomas, Anita Hill case, because as far as I know, that was also pivotal to changing the public debate, although ultimately it didn't stop Thomas from becoming justice on the Supreme Court. Let us know your thoughts on that and how it ties into everything we've talked about so far.
So in 1901, Clarence Thomas was nominated to the United States Supreme Court. And in the United States, before you actually become a Supreme Court judge, you have to pass a confirmation hearing in the Senate where they ask all sorts of questions of you. They have witnesses who testify about you. And in his confirmation hearing, Anita Hill, who was a law professor who worked under Clarence Thomas at the Equal Employment Opportunities Commission, which is the United States version for, they're like the watchdog. If you've been discriminated against, you can go to them and you file a charge, and sometimes they will investigate and even prosecute on your behalf. But it basically is the first level if you have a sexual discrimination case. So it's ironic that she's working underneath Clarence Thomas at the EEOC, this organization that is against sexual harassment, trying to protect victims of sexual harassment, that he would subject her again and again to graphic sexual conversations, talking about pornography and all sorts of unwanted sexual attention. And one of the things that people remember from these hearings is she testified that there was a hair on her can of Coca-Cola. And Clarence Thomas said, "Oh, what is that, a pubic hair?" People obviously thought it's inappropriate. He shouldn't have said it. And it's something that everybody remembers. Oh, yeah, the pubic hair comment. So he was, in fact, confirmed, and he became a Supreme Court justice. He is now deciding cases that impact the rights of victims and so on and so forth. But the silver lining from all of this is that the year after she testified about the sexual harassment she was receiving, that the number of harassment complaints, the number of women who stood up for themselves that were filed with the EEOC doubled. And so a lot of attention was thrown in the area of sexual harassment. And for that, we thank Anita Hill for help in our industry.
Thank you for outlining that. We will be a little bit breezing through a number of cases that relate to it, all of which we could devote an episode. Maybe we will down the line, and maybe we'll bring you back then. Jumping more into more present day, although to me, anything before the pandemic seems like a long time ago. I actually had no idea until we had the pre-interview chat that you told me one of the pivotal modern legal acts that's relevant to trying cases of workplace sexual predation is the Trafficking Victims Protection Act, which I was immediately confused by. You explained many people are confused by, juries are confused by. I read it was passed in 2000. I'm not sure how quickly it started to be used for these kinds of cases. I think some people might know it came up in the P.Diddy case. Do I recall correctly also in the Weinstein case? Can you make sense of all of that for us?
Correct. So the TVPA, the Trafficking Victims Protection Act, has been around since 2000. And this case was basically, on the surface, meant to protect victims from being sexually abused in terms of forced sexual labor. And there are other components about it that back then you didn't hear much about. And one day, a couple decades ago, I had a real serious case come to me, a sexual abuse case by a woman who was sexually abused by her boss at work. And it happened maybe 6 years prior. And I'm digging everywhere. How can I still help this woman? How can I still represent her? What can I do? Because the statute of limitations for a lot of these cases run anywhere from 6 months to 3 years and maybe 5 years, because it's changing over the time. But back then, there really wasn't anything. So I came across this statute, and it says that the time to sue is 10 years. You have 10 years to sue. I said, wow, that would cover this case. And I started to delve into it. And if you start reading more, it actually talks about any time there is anything exchanged of value received or given by anyone involved, where there is a sex act, anything that involves sexual gratification, there can be civil and criminal liability. What this means is, take, for example, Harvey Weinstein, the famous movie producer, internationally known. And he had the casting couch. And the casting couch, if you have sex with me, I'll put you in a movie. I'll consider putting you in a movie. And in one of the famous cases, Noble v. Weinstein, the judge allowed this particular statute, the Trafficking Victims Protection Act, to be applied to a woman who was forced to have sex, or I should say, not coerced, but she was manipulated into having sex with Harvey Weinstein with the promise of a job. And they said, absolutely, this applies. And since then, we have had many other cases where, in just a salary situation, where a boss makes their subordinate have sex with them, that can be considered sexual assault under the TVPA. So this is a statute that is now being broadly interpreted, but the problem with it is, from its name, Trafficking Victims Protection Act, you think to yourself, oh, this only applies to a case where a young woman is thrown in the back of a van, taken to a brothel, and forced to have sex for money all day. Well, of course it covers that, but it covers a lot more. And that's why we are using it. I just wish the title of it was a little different.
Another very prominent case where this act came up, and we can kind of see where juries get confused, or it's always multifactorial, especially the outcome of a high-profile case, but the P.Diddy case, where we have this strange situation where he is acquitted of most of the charges, but something about movement he is charged with, but not the ultimate harm that came to the victims. That's at the core of the trafficking charge, the sexual exploitation itself. He moved women for the purposes of exploitation, but it's not directly. I'm still confused about that. I think most people were. Can you elucidate on that for us?
Sure. So the P. Diddy case, I actually attended the trial. I reported on the trial. And I could tell you that from my impression, what I saw is that, yes, he forced this woman, several women, just from what I observed from the testimony, that he forced these women to have sex. And he forced these women to have sex involving something for value, whether it be money or promises or anything like that. And the problem I felt is that the prosecution bring charges against P. Diddy for violations of the Trafficking Victims Protection Act and also the RICO racketeering statute, basically, again, that's something that was enacted to fight the mafia, organized crime. So it was a bit of an overreaching to try and say that it was like organized, it was crime, it was an enterprise. But the stereotype that when people hear sex trafficking, Victims Protection Act, trafficking, that word, and then the racketeering statute, mafia, it just is very hard to prosecute under those statutes. Whereas the language of the statutes themselves, the actual ingredients, which says what you need to prove to win this case against P. Diddy, to have him convicted, it's much easier. And so did he give anything of value? Did he make any promises? Did he force anyone to have sex? Yes. The whole idea of transporting doesn't even need to happen. Doesn't even need to be trafficking. It could be just, like I said, what's known as a commercial sex act. And with respect to the racketeering, that, it was a whole organized movement, criminal enterprise, it was very difficult. So looking back, this is a case, in my humble opinion, that would have been best if it was brought under the state claims of sexual assault, and you didn't have to get into these complicated understandings of a federal trafficking law, a federal racketeering law. And so for that, the jury let him out on the least detrimental statutes, which was basically using prostitutes.
So what I'm hearing and what you've described so far is that if you have a victim with this, what you said, it happens in every industry. These are really grievous crimes that cause a lot of distress, economic harm, even to the point of suicide for victims. But still, in this day and age, we do not have obvious, clear laws with enough time for victims to pick themselves up and seek help. Like, the laws are still not there, which there should be obvious choices for a team representing a victim, that either because of statute of limitations or because of the name or other aspects going to be a huge challenge to get through in court. It's infuriating that such common crimes do not have, you're the one with the legal experience, correct me if this is a common experience of victims of crime, that their team has to find roundabout ways to defend them, because it seems to me like there's a big problem, that's putting it too mildly, the system is not working. Am I making sense?
You absolutely are making sense. However, just because we were talking about the Trafficking Victims Protection Act doesn't mean that's the only way to go after a sexual abuser, a sexual harasser. In fact, there are more statutes and more ways to go against sexual harassers and sexual abusers than ever. And it's easier than ever to prove your case nowadays. So those are just statutes that, yes, you kind of have to twist and contort yourself to be able to sue under. But for the most part, no. You can sue your harasser for sexual harassment under the standard employment law statutes. You can sue your harasser under the standard assault and battery statutes, common law. You don't need to have to jump through hoops and contort yourself to be able to sue under those. Those are just rare exceptions. But for the most part, it is very easy. And in fact, in New York and California, they have but the most lenient statutes to sue for sexual harassment. In all over the United States, except for California and New York, if you want to sue for sexual harassment in the workplace, it has to be what's known as severe and or pervasive, the sexual harassment at work. So one instance is not enough. It has to be totally severe if it's not going to be pervasive. And I could talk about that in a second. But New York and California, anything of an offensive, unwanted sexual act, comment, or conduct, that suffices. That's enough. But outside of those states, again, you got to jump through some hoops. You got to show that it's severe and or pervasive. And if I may, I tell my attorneys or I teach my clients what's responsible for that, how you prove that. So take, for example, the Anita Hill that we were just talking about. Anita Hill, sitting there having lunch, with Clarence Thomas, her boss, and let's say he just says, "Oh, what is that hair on your coat? Is that a pubic hair?" So that would not be very severe. And if it happens once, that would not be pervasive. But let's say that that happened every single time they go out to lunch, again and again and again, 3 days a week for 8 weeks. Now we're looking at something that's pervasive, and that would allow her to sue. On the flip side of that, I bring up Bill Clinton. Bill Clinton and his case involving Paula Jones. Paula Jones was a subordinate of his, and he was alleged to have called her to his hotel room and dropped his pants and said something to the effect of "suck it," exposing his naked penis, demanding a blowjob from a subordinate. That's just one time. That would satisfy the severe without having to be pervasive. There's no need for that to happen again and again and again. And the courts have also found that any act of touching, any sexual part, is also enough to sue for. So while there are hoops you have to jump through, it's not that bad. A good lawyer can help with that in the case. And like I said, New York and California, no longer necessary. It's just become much easier to sue for sexual harassment.
We want to take a moment to thank you for your listenership. As an independent volunteer collective, our episodes are only made possible because of donations from people like you. Please visit our website, www.redlightexposé.com, and click the Donate tab. There, you can find ways to financially support us one time or on a monthly basis. Your support is greatly appreciated. And now, back to the episode.
There are significant challenges, but that does not mean it's not worth taking up a case. Do I recall correctly, in the Clinton and Jones case, they settled out of court for, I think, a six-figure sum, a very high six-figure sum. In our pre-chat when we spoke, right, this seems intuitive, I think, to most of our listeners. Most victims, especially if they are accusing a high-profile person, do not want to have a court case that has journalists recording every minute of it. Worst case is televised. I'm still appalled that any court cases involving intimate trauma are being televised in some cases in the US. That's shocking to me. Most victims would like to keep it as private as possible, have as few people know as possible, and settle as quickly and privately as possible. Is that right?
It depends. I have many clients who are happy to scream what happened and announce their name from the top of the mountain. And I have other clients who say, I want this to be as confidential as possible. Even in the P.Diddy case, one of the victims was known as a Jane Doe, and her name was not revealed during the trial. And there's also a provision in American law that in these types of cases, you can bring it anonymously as John or Jane Doe. And, you have to make a showing to the court that you're scared, you're a victim of sexual assault. Bringing up your real name would have a chilling effect on others who would not come forward with their legitimate claims of sexual abuse, sexual assault. So there are ways to come forward anonymously. As far as the publicity that you were referencing, sometimes you'll have a judge who says, no, I'm not going to allow this, because the general premise of litigation in the United States is that lawsuits are public, and even more public are the trials, because I've seen cases where judges said, okay, the entire litigation, we're going to allow you to be a John or Jane Doe, but at the time of trial, you have to reveal your full name. Yes, people do have the option to proceed anonymously, and let's not forget that many of these cases settle pre-litigation, pre-lawsuit, before the lawsuit started, and nobody's name is revealed. And very often the victims and the harassers both want a non-disclosure agreement where everybody agrees not to say anything about what happened, and the victim is hopefully compensated, and each side goes their merry way.
There is one thing around these cases that you shared in our pre-interview chat that I wasn't totally surprised by, but it was unfortunately dispiriting, which is that there is a significant challenge in many cases for juries to end up sympathetic towards the victim. Specifically, you said that in your assessment, post-Me Too, the climate is more hostile, that there is a fatigue almost around these crimes, and that the narrative of these women are trying to make a big buck quickly with false accusations is not really fringe thinking, but still very prominent, if not in some ways more prominent. But you find your, I guess, oral techniques of working with that sort of thinking when in court, best you can, challenging that when it comes head to head. Can you get into some of that? Getting that gold digger myth that is so prevalent because it's everywhere. The conniving woman who's got it out for her boss, or who is a jilted lover just trying to seek revenge. We experience that as feminists and human rights activists to get people to understand, no, this type of abuse from the boss to the employee is not a rare thing. It is extremely common. And that's an ugly part of our society we have to face up to.
Yes. So when I started in 1995, this type of work, you would bring a sexual harassment case and you would just tell this to a jury, you would tell this to a mediator, tell it to a judge, and there was almost a gasp, sometimes an actual gasp, and you were believed. You were believed. And the person who was accused was immediately seen as the actual harasser, that they did it. So the Me Too movement is a double-edged sword. The Me Too movement came around, and it was wonderful because women are standing up for themselves, and we have more cases of sexual harassment and sexual discrimination that are coming out ever before because they feel empowered by this movement. That is wonderful. But the flip side of that is because you do see a lot of them, that sometimes it's an uphill battle against exactly what you were just talking about. This concept of the gold digger. Oh, she's making it up. Oh, she's just trying to get ahead at work and she didn't get ahead and now she's suing for it. Or, oh, she just got caught cheating and now she's, trying to make some money out of it and show her husband that she wasn't cheating and she was just forced into it. By the way, we're not oblivious. There are great, wonderful people in the world, and there are also some evil people in the world. So there are some gold diggers out there. There are people who lie. Let's be real. We know what the world is about. But for the most part, when somebody is going through this and this happens to, we believe them. And we prosecute the case and we gather evidence. And you know what? In many states in the United States, I don't know how it is in Germany, you could record on audio using your iPhone, a pen, whatever, the person talking, and you could catch them.
Not in Germany, unfortunately.
I even had a case involving a boss who was sexually harassing a subordinate, and my client bought a pen with a camera and microphone on it that was right on the desk and recorded the video of him actually doing it. So in the wake of the Me Too movement and a little bit of backlash as to, oh, I don't believe it, a lot of women are coming forward with actual proof, video, audio, could be text message, or it could be witness statements too. That works very well as well. And even if it's just a he said, she said situation, so be it. That is the nature of these types of cases. And that is why a jury gets the privilege to listen to each side tell their story and then make a decision, make a verdict on who is telling the truth.
And in your experience, even a initially reluctant jury can be brought around. There are ways to change minds in these court cases. I mean, of course, you can't quiz the jury beforehand about their thoughts on these types of crimes.
An experienced lawyer who has been doing this for a while, who knows how to try these cases, you're going to have to talk to the jury. And you're going to have to say, listen, members of the jury, I know that you're going to hear from the defense and you're going to hear that, oh, my client is such a bad person and she's making this up and she's just doing it for a money grab and everything like that. But you know what? I want you to look at the evidence and I want you to listen to the victim and I want you to listen to the way she describes and you start to talk about it. But it is unwise for a trial attorney trying a case like this to ignore that potential bias. You have to hit it head on and you have to metaphorically get in the seat next to them. Be like, I get it. I understand you may be feeling this way or whatever, but you know what? Once you start to look at this over here, you're going to see that she's telling the truth.
I do actually have one last case, which I know we only have a short amount of time for. We didn't talk about this in our pre-chat, but I'd love to know if you have thoughts on it. The Lively Baldoni case, Justin Baldoni, Blake Lively, which I know there's been a lot of lawsuits in both directions. On this podcast, we are inclined to believe Lively's version of events. Just for people who don't know the case, can you summarize the allegations? And I don't know if you've seen the rhetoric from the Baldoni defense that Lively was hoping for a love affair after just having given birth to an infant, by the way, with Baldoni. And because he rejected her, she's now trying to ruin his life. This is being discussed across the internet. This is like almost Depp versus Heard #2.
So I only represent victims. I don't represent employers, harassers. I don't. And every opportunity, I stand up for the victims. But there's an obstacle that we face, and that's the law. The law only allows to sue for a certain level of sexual harassment that we were kind of talking about before. And I read the complaint when it first came out. And from a sexual harassment case, strength, it wasn't very strong. Maybe some comments about, if I recall, her weight, the direction of the sex scenes. My recollection of reading the complaint was it wasn't a very strong complaint. And I said, I wouldn't be surprised if the sexual harassment causes of action get dismissed. And a couple of years later, sure enough, the judge dismissed the sexual harassment causes of action. And what the judge allowed to stay were the retaliation claims. And that's really important because you could have a very weak discrimination, sexual harassment case, but what happens is the second you complain about it, that starts a whole brand new case. That is now known as a protected activity. The complaint that you did yourself is a protected activity, and you can't be retaliated against in any way because you did that. And so the judge says, okay, even though the sexual harassment claims don't rise to the level of moving forward to trial, the retaliation claims do, because the underlying claims don't have to be strong. All that has to happen is you engage in that protected activity of complaining and they do something bad to you. So the judge did allow it to go to trial, but I understand the case did settle, and I understand it settled for no monetary payments.
I'm sure on this podcast we will return again because there's a few more things that I recollect, like Baldoni allegedly talking to Lively about his pornography habits, showing a video of his wife fully nude giving birth, trying to convince her to shoot her birth scene in the movie fully nude. There's more to this as I've read it, but it's important to know that even if your complaint gets dismissed, that should not mean immediate legal retaliation, which doesn't mean it doesn't happen, right? So all kinds of counter lawsuits sometimes do occur. Is that libel lawsuits, or what is ways in which sometimes accused men do, or mostly men do, retaliate?
So when we talk about retaliation, we talk about retaliation in terms of adverse employment actions. So they do something to you at work that makes it more difficult, that takes away a job perk, an element of your job. And that's what I'm talking about. With respect to defamation, anything said in a lawsuit is subject to absolute immunity, privilege, meaning that Baldoni can't sue for it, she can't sue for it, you can't sue for defamation for it. Outside of the lawsuit, if one of them goes to the press and says something, you can sue for it. For example, Donald Trump said that E. Jean Carroll was lying about him sexually assaulting her, and she sued him for defamation. Didn't have to do with the actual sexual assault, but for defamation. And that was in the public, so it wasn't protected like a lawsuit. And E. Jean Carroll ended up getting an $85 million verdict, which is still the subject of an appeal right now. But yeah, that's something that happened outside. And by the way, what Justin Baldoni did, and I did read the complaint, it is sexual harassment. It is offensive. But legally speaking, we do have certain thresholds that we have to get over, and the judge didn't find that threshold was met.
Thank you for clarifying, and apologies if I'm messing up on these legal terms, because obviously I have no legal training either in Germany or in the US, so I might be jumbling some of these words, mixing them up. So we're getting towards the end of the conversation. I kind of have two last questions. One is hopefully a little bit more optimism. When you support a victim in one of these cases, and especially if you can tell that they're struggling a lot, is there sort of best practice developing on how to support someone through it? Because I'm assuming a lawyer's job is not necessarily mental health support. Are there mental health professionals that you work with to assist victims? Are there other people who come in? Is there any role in bringing in people from the person's family, if they're not already present, to make sure that victims don't have to go through the process alone or with one or two professionals only?
I'm really glad you mentioned that because this is a huge part. It's mental health. And these types of post-traumatic stress disorder cases that we see, these types of depression, anxiety, it's so horrible, it's so sad. And if you don't get the right help as quickly as possible, it's something that can become so bad, so horrible, that it could possibly be something that is impossible to recover from. So as a lawyer who does this, you're not just their lawyer. In the beginning, you do have to take on a small role of somewhat being a psychological counselor. And yes, giving them a list of resources, of psychologists, opening up their health insurance app with them right there in my office and saying, let's see if we can find you a good psychologist near you who specializes in this type of thing.
Support groups, are those available?
Of course, support groups, psychologists, antidepressant medicine, whatever it takes. There's a whole process. And one of the things that really helps this process is actually coming forward and having agency and doing something about it, that they are standing up for their rights. And when a woman comes to my office and I can see she's hemming and hawing and not sure she wants to go forward, I ask the following question. I say, if this is your daughter, if this happened to her, if this happened to your sister or your mother, what advice would you give them? And if the advice is to move forward and stand up for yourself and fight back against these a-holes who actually did something to you, then you should give yourself that advice. And that's something that gives these people power and it helps their recovery along the way.
I'm glad you said that. We've talked a lot about how hard it is for victims and how there's a lot of different mechanisms stacked against them. And still, when we can talk about that on our own team on this podcast, we have survivors of really, really severe sexual exploitation and trauma who can say that it's not for everyone at every stage of their life, but advocacy as well as suing the people who traumatized you can create a sort of inner release. Liberation is a strong word, but in a way it is a mental liberation from staying quiet, staying meek, that can bring people back into a sense of agency. And there are, of course, successful lawsuits in this area where victims do actually get a level of justice and perpetrators are held to account. So this is not totally futile. Finally, very last question is, could you name top 3-4 things that sort of need to happen legally, culturally? You mentioned you're part of the National Employment Lawyers Association, which does some advocacy in this area to go beyond helping individuals and changing the culture, changing laws to create better protections. What are some key things that need to happen the next couple of years or decades?
So one of the things that have already happened that is amazing, that makes me so happy, is the ending forced arbitration in sexual harassment cases. And the first thing many employers do whenever they hire someone is they have that employee sign an arbitration agreement, which says that, okay, if you ever have a case against us for anything, that it goes to arbitration and you give up your right to a jury trial, your constitutional right to have a jury of your peers decide your case. And instead, it's going to be some lawyer or retired judge who's going to decide your case, who's probably calloused and nowhere near as good as jurors. So early on in my career, when I would have an employee who signed one of those, sure, I became, an expert in trying to get out of those, but it was very difficult. And a lot of times we were stuck with these arbitration agreements. In 2022, we now have all sexual harassment cases. There's no more arbitration across the United States. Wonderful. I would love to see extended statute of limitations. So we mentioned before about the 10-year statute of limitations under the TVPA, but it's a little bit of contorting yourself and moving the case in a way that makes it comply with the statutory requirements. But for the basic ones that now have a 300-day statute of limitations or 3-year statute of limitations or 2-year, depending on the state, I think we need to extend those because very often women don't have the courage to come forward, or they don't even come to terms with the fact that they were sexually abused until many years later. This is something that psychologists refer to as inconsistent victim behavior when they are sexually assaulted. They don't always behave the way you would logically expect them to. Sometimes they like to change the narrative and in their head, and sometimes even outside their head, pretend that this was a wanted sexual act. And then they realize years later, what am I doing? That's not true. And so for this exact reason, we need to extend the statute of limitations further out to help these victims. And as far as damages are concerned, some states have caps on punitive damages. Some states don't even have punitive damages in these types of cases. And there are two main types of damages. One are compensatory for the harm and what you've gone through, and the other one is punitive, which has twofold of a purpose. One, to punish this person for sexually assaulting you, and two, to deter them and anyone else who hears about this verdict from ever doing that again. And I think universally, all throughout the United States, all states should have punitive damages that are not capped so that it can send that message, again, trying to eliminate sexual abuse as much as possible in our society.
Is there any chance of, because you mentioned the name of the Trafficking in Victims Protection Act is challenging, any chance of changing the name of the act to sort of reflect the full scope, full spectrum of crimes it's actually practically being used for and people it needs to protect?
That does require a congressional act. I don't even think it should just be the title. In addition to the title, make it easier. Very simple. Anytime a person forces themselves on another person sexually, you have a case. You don't need anything else, any more hoops that have to be jumped through. Just make this on a federal level. But let's not forget, all of the states have, for the most part, great laws in this respect. But this is the floor, not the ceiling, for cases in that it's universal all throughout the United States in the event you don't have a state cause of action because the statute of limitations has expired.
Okay, well, thank you so much. Are there any final last thoughts, messages you want to leave our audience with?
Absolutely. You don't have to be a victim. Stand up. I promise you, you will feel agency. You will feel power. It'll be a little scary, but that's okay. Anything worth doing is a little scary. Very often you can do it confidentially. Do your research, whether you're in Prague, in Munich, in California. Find someone who does this, who can be your support, who can be your partner all throughout the process and make it as, not as easy, but as the least amount of trauma for you going forward. You're a victim, but you can do something about it, and you could really gain some power and punish these people so they don't do it again, and hopefully so you can also get compensation for what you went through.
Thank you so much, Derek, for your time. And maybe in the future, we'll have you back to pick apart one of these cases in more detail if you're interested.
I would love it. Thank you very much for having me.
Thank you so much.
Take care.
Thank you, everyone, for listening.
We hope you found this episode informative. To follow us on social media, click the links in the show notes below. If there is a topic you would like us to cover, you can contact us at redlightexposé.podcast@gmail.com or head on over to our website, redlightexposé.com. There you can also find a donation page if you'd like to support the show. All the hosts at Red Light Exposé are volunteers, so we rely on your donations to continue to compensate our survivor guests and cover operative costs. Thank you for listening. We hope you tune in next time.